I'd like to welcome Minister to the House and wish to concentrate on two aspects of the bill. The first, the termination of local authority tenancies. Section 62 of the Housing Act 1966 has a long history of litigation before our superior courts, going back more than 10 years at this stage. As senators will know, that section gave the relevant council wide-ranging, unfettered and summary powers to deal with tenants who they considered in breach of their tenancy agreements. This more often than not concerned allegations of antisocial behaviour and, to a lesser extent, the non-payment of rent. While I acknowledge the more recent decision of the Supreme Court in Donegan versus Dublin City Council, the matter first commenced with a decision of the Supreme Court in 2005 in a case that had already come before the District and Circuit Court. That decision was in the case of Dublin City versus Fennel. The Council won that case on what could be described as a technicality, given that the Supreme Court held that the European Convention on Human Rights Act did not have retrospective effect. There then came the High Court case of Pullen and others versus Dublin City Council, where two judgments were delivered in 2008 and 2009 respectively. In the first of those judgments, the judge found that the state body, in other words the local authority, had breached its statutory duty under Section 3.1 of the ECHR Act 2003 in seeking to evict the plaintiffs from their home without affording them certain procedural rights. Those rights were, of course, in the nature of a review or appeal. The court awarded €20,000 to each of the plaintiffs on account of their distress, anxiety and loss of reputation and damage suffered. The second judgment concerned what injunctive reliefs were open to the court in the case and do not concern us here. Lastly, we have the decision in Donegan, handed down in 2012, on which the revisions of Section 62 contained in this legislation are based. While I acknowledge that the Department wanted the conclusive guidance of the Supreme Court before advancing amending legislation, it was surely obvious, as it was to legal practitioners in the area, that such legislation was warranted some years ago. This time lag again illustrates the very great need for the soon-to-be-established Court of Appeal, and I wish to pay tribute to the former Minister for Justice for bringing the establishment of such a court about. In relation to the present bill, it seems to me to provide warranted safeguards in relation to tenancy warnings and repossessions, and I'm glad to see that in relation to repossessions, an application to the District Court, appealable in the Circuit Court, is to be the way in which such matters are handled. It is a positive, then, that in place of granting the possession orders through the local authority, the court may instead, if it so wishes, grant an exclusion order against an individual without affecting the right of other members of the family to remain in the dwelling. It is a sensible provision, I believe. I also welcome the provision allowing for some or all of the proceedings relating to possession orders being held in camera, given the sensitive matters that will be considered. And given the various decisions of our superior courts in relation to this issue, I think the bill is a very good response to the issue and gives a workable right of appeal to tenants while preserving and protecting the ability of local authorities to deal with antisocial behaviour and the non-payment of rent. The second issue I want to deal with is the housing assistance payment. This is the most radical shake-up of state family housing support in decades, and it will for the first time allow those in receipt of housing assistance payment to take up employment which current rent supplement recipients cannot. At present, working families who work more than 30 hours per week are not entitled to the supplement. This bill will do away with that requirement, allowing full-time work. We are all aware of the difficulties faced by working families. This bill will help them. Threshold, the voluntary housing organisation, has strongly welcomed the HAP, and it is in its 2014 budget submission it said, and I quote, that the new housing assistance payment is recognised as a critical measure to improve employment activation. Additionally, the Dublin City Council pilot scheme will specifically target the homeless, and that is very much to be welcomed. In relation to the present difficulty with landlords accepting tenants in receipt of payments, the new scheme will see landlords paid directly, thus removing the possibility of arrears and making such tenancies more attractive. It is simply untrue to say, as some in the opposition have, that those on HAP payments will be excluded from other social housing. Any such person wishing to avail of other forms of social housing will be able to be included on a transfer list from which housing will be allocated when it's available. I very much welcome this bill, and I commend you, Minister, for a very thorough piece of legislation that will be much needed for working families. Thank you.